going to...
Welcome everyone, good evening. This is an event organised between InterEngineering LGBT, Thrive Law and the Law Society. Tonight we've got Imogen and Tom who will talk about LGBTQ plus rights in the workplace, equality and practical resources. Just before we kick off, I just want to quickly do a bit of housekeeping and just to let you know that if you have any questions on the topic that's being discussed, you can use the chat to ask your questions in there. If it's anything that's sort of pertinent and on one of the slides, we'll try and do our best to pick it up straight away. Otherwise, we'll have some time at the end for the questions. Like you may have seen, this is being recorded with the intent to use it in the future for podcasts and as a resource. We won't name anyone, so if you have any questions that you don't want to you don't need to worry about anything like that. We'll just pick up the questions as they come. We have a few things that we've released recently with InterEngineering. So we've got a mental health podcast, which will pop the link in the chat as well for you to check out later. And we have an engineering summit coming up in person at the end of October. We'll put that in the chat as well if you're interested to come in and represent your company at that event. And on that note, I'm going to hand over to Imogen and Tom for the presentation.
Thank you so much, Remy, and thank you to InterEngineering for asking us to host this event today. So the idea is that we're going to take you through LGBTQ plus rights in the workplace, but of course we don't want to keep it dry and only talk about the legal aspects, although both Tom and I are lawyers. We also want to let you leave here today with practical resources and feel like you know exactly what to do to help the cause moving forward. So just by way of introduction, I'm Imogen Hamblin, and I am a member of the LGBT plus committee of the Law Society, which is how InterEngineering connected with us, as Tom and I have both done a podcast on harassment in the workplace around LGBT rights, which is something that we'll touch on a little bit today. I'm also an employment solicitor, so I am Tom's colleague. I'm a member of the LGBT community, so I identify as a cisgendered lesbian woman. And I'm also a lecturer at ULaw in Nottingham. Tom, if you'd like to introduce yourself.
I'm Tom, that's me on the right with my pre-pandemic hair, which I'm wishing I still had right about now. I'm an employment lawyer as well. I identify as a straight male and very much an ally to the LGBTQ plus community. I was saying just before we let everyone in that this is something that I feel very passionate about because of the fact that there are so many organizations which are still run and managed by people like me and older, but people who are perhaps not allies. And one of the things I've noticed as a white straight male is just the amount of privilege and how easy I've had it in my career. And so I very much try to invest my time in promoting equality and shining a light on these issues, the unconscious biases and the challenges faced by women, the LGBT community, people with mental health, because I think doing so and having people like me do it is a good way to try and sort of level that playing field. So that's why we're very keen to talk to you today about this. Do you want to jump onto the next slide, Imogen, for me? So this is us, well, some of us anyway. Which is
I realise actually, Tom, you and I actually don't feature in this picture.
No, we don't. I can't remember why I wasn't in that photo shoot. Probably because I didn't want to be forever captured with long hair, I suspect. So we're a boutique firm. We specialise in employment law, HR, wellbeing and diversity and inclusion. We're all lawyers, so we all come from a traditional legal background. Most of us have worked in big firms. But we're all brought together under the vision of Jodie Hill, who's the lady in the white trousers there, who set the firm up about 3 years ago to create a platform to provide legal advice and HR support in the context of a values-driven organisation, to establish a platform to promote equality, to give people a better voice and to try and do things differently to most law firms. So that's very much what we're about. We spend a lot of time advising on these sorts of issues, both to try to educate people like yourselves on the rights that they have in the hope that they won't then have them mistreated, but also to support employers in understanding how they can be better, how they can support the community better, how they can train and educate their people to help create a more equal platform at work. A little bit of housekeeping. We have the chat function. Please do use it as much as you want. We're keeping an eye on it. If you've got questions, jump in with them at any point. We're happy to be interrupted to stop and to answer questions. Neither of us wants to talk at you for an hour, and you probably don't want to be talked at for an hour. So make it as interactive as you like. There will be things where you might have queries, or if we haven't explained it properly, just jump in, please do. The session's being recorded. Make notes if you want, but it will be available afterwards. And you're all on mute, which is fine. But I say this more for me really because I have both cats and a 2-year-old. So I like to make it clear from the start that they're very welcome in the background, because inevitably one of them is going to come bursting into this room at some point, and you'll hear them in the background. So that's fine. The more distractions, the better. We don't mind the slightest. So why is this such an important topic? These are some stats from the 2018 Stonewall report at work. And as you work down them, you start to realize the challenges that are faced by the LGBTQ+ community, which just simply aren't faced by people like me. And like some of these are shocking, if I'm honest. They're absolutely shocking. If you think that more than a third of LGBT staff have hidden their LGBT at work, so that constant self-editing in work all the time. You come back from a weekend, easy for me, I just say, oh yeah, my wife and I did this. But a third of LGBT staff are self-editing everything they say for fear of outing themselves in an environment that they don't feel comfortable with, which is incredibly sad and incredibly challenging. 2 in 5 bi people aren't out to anyone in work about their sexual orientation. 1 in 4 trans people aren't open with anyone at work about being trans. So those are high percentages, significant minorities. Almost 1 in 5 LGBT staff have been the target of negative comments or conduct from work colleagues because they're LGBT. That's a lot. If you know 5 at work, 1 of them has probably been subjected to some form of discrimination. Almost 1 in 5 said they were looking for a job that was held against them. For any of you who've been looking for jobs in the last few years, it's hard at the best of times. It's even harder if just being who you are is another hurdle to try and overcome, alongside all of the natural competitiveness of applications. And then perhaps one of the most shocking is 1 in 8 trans people have been physically attacked by customers or colleagues in the last year. I mean, if you're not part of the trans community, can you imagine? I can't even comprehend being physically attacked by a colleague at work. So the fact that so many people, no, to answer Caitlin's question, no, you absolutely don't. Absolutely don't. If you're interested in this, and if you're an ally, that's exactly the sort of person who we want attending as well. So some of these stats put into perspective why this is such an important topic, because it impacts so many people so significantly. So what is the Equality Act? The Equality Act is the legislation which underpins everything that we're going to talk about today. All aspects of discrimination law, as you may have heard of it, are enshrined in the Equality Act. It came in, it was in 2010, to replace a myriad of regulations and legislation and statute which have been in place over the last 50 odd years or so. I mean, interestingly, slightly distressingly, you can see the dates of those. Those are the dates upon which it became unlawful to discriminate against people with that characteristic. So you could actively discriminate against women before 1975, for example, and actively before 1995 for anyone who's disabled. The sexual orientation regulations 2003. So some of these developments are quite recent. It's not that long ago that various people with protected characteristics could still be discriminated against. And we've got a long way to go. The Equality Act has helped with that. So when is discrimination unlawful? Now, there's an important distinction between being treated badly and being discriminated against in the legal sense. And it's quite important to understand the difference. So the Equality Act includes 9 protected characteristics. If you're treated badly at work for a reason that doesn't relate to one of these protected characteristics, it's not discrimination for a sort of legal sense. It might be bullying, albeit that's not a defined term in employment law. Might just be unfair treatment. But if it's just a case that everyone is treated badly, then it's not discrimination. And in fact, you'll sometimes see employers run what's called the bastard employer defense, where they say, look, I haven't discriminated against this person because they're gay. We treat everyone like shit, if you excuse my language. And strange though it sounds, that's almost a defense to discrimination. If you treat everyone badly, you can't be singling people out with a protected characteristic. I mean, it's not perhaps how you want to promote your business. Say we treat everyone terribly, so just get used to it. But it is technically a defense in itself. So as well as having to have a protected characteristic, then discrimination needs to manifest itself in certain types of behavioral conduct, which we'll come to, the certain types of claim. So the protected characteristics, if you could click through so they're all on the screen for me, Imogen, thank you. So these are the 9 here. These are your protected characteristics. They're all largely self-explanatory. And you will see one in particular, which is especially relevant to the LGBTQ+ community, which is sexual orientation. So it is unlawful to discriminate against someone because of their sexual orientation, just the same as it would be unlawful to discriminate against them if they were male or female on the basis of sex or on the basis of their age. So sexual orientation is the one that we're really focusing on, albeit obviously gender reassignment is very relevant as well. Touching on gender reassignment, this has been the subject of quite a lot of discussion recently around how they should change it, how they should define it. But essentially, it's anyone. Right. Hold that question on non-binary. Crap, I'm so glad you asked that. That's like a planted question almost. Yeah, hold that thought. I will come to that. Yeah, absolutely. So gender reassignment is for anyone who is proposing to undergo, is undergoing, or has undergone a process of gender reassignment. It is unlawful to discriminate against anyone because of that. Now, proposing to undergo can essentially catch someone very early on in the process, which I think is a good thing. We don't come across a huge amount of these claims in terms of gender reassignment. But I do think it's one where there's a great deal of further education that's required around what that process looks like for individuals, the various stages of it as well. Obviously, there's been quite a lot in the media and the press over the last perhaps 2 years around things like gender neutral toilets and who is expected to use which toilets and at which stages of the process. Now that's beyond the scope of today, but there is quite clear legal guidance around how that applies. That's something that if it's relevant to anyone's employer that we can follow up with separately. But I could go down a whole rabbit hole for an hour on that just on its own. In terms of sexual orientation, so sexual orientation is limited to a person having a sexual orientation towards persons of either gender or persons of both gender. It does not cover any wider sexual practices or sexual conduct. So it's sexual orientation, not sexual proclivities, is perhaps a good way to explain it. Circling back to the question about non-binary and how that links to gender. Now, Imogen, correct me if I'm wrong, but at the moment, the Equality Act only protects for sex discrimination for men or women. It doesn't capture non-binary or gender fluid in the legislation?
Correct. Yeah, the legislation is silent as to the issue, but obviously we'll come on to talk about the important Taylor and Jaguar Land Rover case, which has brought the definition of non-binary into this gender reassignment category. But you're absolutely right, Tom. The legislation is silent, and certainly there's a query as to whether it would be identified as sex discrimination.
A nice little segue to promote your part of the talk for later on there. See what I did there. Right, if you can move on to the next one, please. So discrimination in the workplace, there are essentially 4 strands of it. There is some extra strands when you're dealing with disability, but that's not really relevant for today. You've got direct discrimination, indirect discrimination, harassment, and victimization. Harassment and victimization are terms which have specific legal definitions, but which are thrown around quite loosely, I think, in the context of workplace disputes. So hopefully today you'll be able to come away from this understanding what they mean in practice and when something might be harassment versus when it is perhaps just what you would normally describe as bullying or unfair treatment. Then we'll look at what defences there are to discrimination. So surprisingly, there are occasions when you are allowed to actively discriminate against people with a protected characteristic, which might seem strange. Taking the second one first, positive action is where you have an underrepresented group and you are taking positive action to try to address that lack of diversity perhaps in your workforce, maybe by, to use an example, if you are very underrepresented from an ethnicity perspective, you might actively advocate for candidates from a certain race or ethnicity. And in certain circumstances, that is lawful. Question from Lynn: are you correct in thinking intersex people are covered in UK law? Do you want to touch upon that when you talk about the cases later, Imogen?
Yes, well, in fact, I'm not actually clear on that in terms of the legislation. Certainly it would be in terms of the case law, as Tom and I discussed earlier, but actually I'm not sure that intersex is recognised in the Equality Act in the actual wording of the legislation. But that's a really good question, actually, and something I'd like to look into further. But yeah, we'll come on and talk about the non-binary categories and the kind of gender fluidity later.
Because I don't think it is it? And I haven't come across a case that has tested it. But I would imagine that on the basis of the direction of travel for case law, then that would be something where if you establish that as your gender, then you would be able to apply the same legal test as if you were male or female, I would imagine. But I just don't think it's been tested yet. I haven't seen it tested. The other one there is genuine occupational requirement, which says where there's a genuine occupational requirement, you are allowed to discriminate. Does anyone want to pop an example in the chat that they can think of? See if they can think of something that would be an occupational requirement as opposed to just maybe a discriminatory preference. Yeah, okay. There's some good examples there. Yeah, rape counsellor. That's a very good example, actually. There's actually some quite clear guidance on that about the need or the ability to recruit women, particularly for that role. Personal care. Personal care is an interesting one. I suppose, yes, that's probably right. Perhaps towards women again.
Well, actually, can I jump in there, Tom? Because I've had a case actually where in terms of, I know this is kind of diverting from the LGBT aspect, but where somebody required somebody of a specific sex because of their religion. So they were Muslim, and therefore at home they wore a headscarf, and therefore they had a job advert advertising for a female to come and care for them, because if they had a male in their home, then they'd have to wear the hijab in the house, and actually that was deemed acceptable to discriminate on that basis.
Perfect example. Someone just put their physical ability in emergency services. That's quite a controversial one, actually, because women are now permitted to serve, I believe, in pretty much all frontline military roles other than special forces. I think. I don't believe women are permitted to say the SBS or the Royal Marines. But other than those, where there is seen to be a genuine occupational requirement because of the nature of the role and how physical it is, physical capabilities is a risky one, particularly because there are often women who are stronger than men. One quite good example is in the theatre. You're generally allowed to cast a woman as Juliet and a man as Romeo, for example, and a claim otherwise. Here we are. They're all open now. Women have applied but not passed. That's interesting. So does that include for SAS and SBS as well, for special forces? Gosh. Oh, that'll be fantastic when someone passes. What a difference that'll make. But I suppose they judge, don't they, at the same physical standards. They wouldn't be able to make any physical adjustments down. So they would need to be able, to pick up and carry, 220-pound men to pass the test, I suppose. That's interesting. Yeah, so those are the only real exceptions. There's actually a film, Lynn, if you remember. Well, I'm showing my age here. There's a film back in the day called G.I. Jane with Demi Moore when she applied for Navy SEALs and they put her through that training. And I remember thinking at the time that will probably happen further down the line. So interesting to see that the military is actually starting to embrace that as a possibility. Yeah, the theatre example, something like it's lawful to cast a woman as Juliet or a man as Romeo because they are male and female characters. And although they could do it perfectly well, and if you remember back in the day, they often used to use men for sort of effeminate characters and things like that in plays. Nowadays, that is seen as a genuine occupational requirement. But other than that, there really are quite few exceptions. If you are treating someone less favorably. Oh, I see, you mean eyesight. Oh, okay, yeah. But if you think about, if you go back to the protected characteristics, Amy, you talk about physical abilities. Having poor eyesight, unless it amounts to a disability, is unlikely to get you within the remit of these protected characteristics. You always need to bring it back to whether or not the treatment is linked to one of those. If it's just something like poor eyesight or a lack of physical fitness, for example, then yes, you would be able to say to someone, I'm sorry, you can't be a frontline firefighter because you simply aren't fit enough or you're too overweight or something like that. But that doesn't link back to the protected characteristics. So we're talking more about if someone is being held back because their age or their gender or their sexual orientation or their race or ethnicity. So always bring it back to those 9 characteristics, one of which, of course, as we know, is sexual orientation. Can we go to the next slide?
Yeah, just before we do, Tom, I just want to jump in here and say, whilst we've listed some of the claims here, these are not only applicable to employees. We've obviously talked about genuine occupational requirements. And what that means is that the Equality Act actually extends to applicants as well. So you don't have to be an employee, you don't have to have a specific length of service to claim discrimination like you do with other claims. It is right from the point of recruitment through to, say, dismissal.
So direct discrimination doesn't come up that often, in my experience. I expect Imogen will agree, because direct discrimination is quite blatant. That is, you are treating someone less favorably because of a protected characteristic. So in other words, I am not giving you this job, I'm not promoting you, I'm dismissing you because you are gay or because you are bisexual or because you are trans. Now, that is overt discrimination. And yes, I mean, it absolutely does still happen. but it doesn't happen nearly as much nowadays as it used to, because whether people have these views or not, and they obviously shouldn't have these views, they have the presence of mind not to exert them overtly in the workplace if they're in a senior position. In my experience, I haven't dealt with very many cases where someone has been clearly discriminated against because of their sexual orientation. Now, hold that thought in terms of things like harassment, but in terms of a decision being based, an unfavorable decision because someone is gay, I haven't come across many examples of that. And that would apply to most protected characteristics. There are not many employers who will say, we're not giving you this job because you're a woman, or we're not giving you this job because you're black. It doesn't happen as much nowadays. There is no defense to it. So if you have treated someone less favorably because of their sexual orientation, then you're in some difficulty as the employer. Now, that all does seem quite straightforward and quite identifiable. You would think if you saw that treatment, you would know it. There's a couple of slight, I suppose, sort of kinks to that, which is that if you move to the next slide, Imogen, please. It's not necessarily your protected characteristic, or it doesn't necessarily even have to be a protected characteristic that you actually have. So here's a scenario here. Shivani was demoted at work after being seen by her manager at Manchester Pride. Shivani's heterosexual but attended with her friend Sarah, who is lesbian. Is that discrimination? So Shivani isn't gay, but has been demoted because of her attendance at Manchester Pride. What do we think? Ooh, yes, by association. Yes, it is. Yeah, we've got lots of yeses. Yeah. Yeah, that's exactly right. So yes, by association. Yeah, that's exactly right. There is a provision in the Equality Act for what's called associative discrimination, which is where you are subject to that direct discrimination. So you're treated unfavorably because of association with someone who has a protected characteristic. And this is a very good example of how it might apply to the LGBTQ+ community. You often see it apply in the context of people with caring responsibilities for a disabled person. Someone is perhaps treated unfavorably because of their inability to attend work functions or something like that, because they have those responsibilities at home. But this is a very good example of how it would apply here. Shivani herself doesn't have the protected characteristic. What she does, in that she's straight, but not one which is likely to result in discrimination. But as a result of her association with Sarah, she's been subjected to less favorable treatment. That gives her a claim for discrimination. And then in the second scenario, which is based, so Imogen put these two together. That is the Thomas Sanderson Blinds case, isn't it, Imogen? Is that right?
Well done for spotting that. Yes.
Yeah, I see their adverts all the time for Thomas Sanderson Blinds, and I have no idea if they make good blinds. I just know that they got hammered in discrimination. Yeah, so this is based on a real life case. So for some time, Paul has been teased by his workmates about being homosexual. He's heterosexual, is very upset by the taunting. His workmates know he is straight. So not only does he not have that characteristic of being homosexual, but they know he doesn't have it. Yet they are still engaging in what they would consider to be banter, but which he considers to be discrimination. Is that discrimination? I mean, potentially it's potentially harassment rather than discrimination, which we'll come to. But yes, discrimination by perception. That's exactly right. I think we must have some people here who work in HR. I think there's there's lots of people bringing out the right terminology here. Yeah, that's absolutely right. You don't have to have a protected characteristic to be protected by it. If you are subjected to unfavorable treatment because you're perceived to be gay, or if you're perceived to be a part of the broader LGBTQ+ community, you can still acquire the same protection. And that goes, yes, it is tangent. All sexual orientation is protected, but I've never come across someone be treated unfavorably for being straight.
No, me neither.
I think it would be an unusual thing. I presume you'd have to have an organization which being straight it puts you in the minority, and where you're treated unfavorably because you're the outsider. You have to flip the whole thing on its head, I suppose. And I haven't come across that, but technically you are right. And I was saying on the perception point, you don't even, it doesn't even have to be an accurate perception. It goes as far as even if they know that you're straight and they still utilize that as a form of, in this case, teasing or unfavorable treatment, then you can still gain the protection, even though you don't necessarily have the protected characteristic, which is forming the basis of the discrimination itself. So there are those examples. Again, they don't come up that often. The next one is far more common, which I think is indirect discrimination. Indirect discrimination is more nuanced. We see this on a weekly basis, perhaps more often than that, all the time, with all of the characteristics. And this is, I think, what people don't necessarily know what to look for. And it's something which, if you understand it, and if your employer understands it, then it's a good, it's where I think significant change can be made. Indirect discrimination is where, on the face of it, you treat everyone the same, which is why it's not direct. But what happens is you put in place a policy, criterion, or practice, which is known in lawyer parlance as a PCP, and that PCP applies to everyone equally. But that PCP places members of the community at a disadvantage, as against people who aren't in the LGBT plus community. Now, I was trying to come up with an example earlier, and I was struggling. So I would welcome any thoughts or input from Imogen or from anyone else. I mean, perhaps a good way to give you some real life context is if you say, we have a PCP in place that everyone works full time at this law firm, at this engineering firm, like full-time working is our requirement. Well, that is still statistically harder for women to comply with because they still statistically have greater childcare responsibilities. So PCP, to work full-time, applies to everyone, but puts women at a disadvantage.
Yeah, can I come in here, because I do have a couple of examples relevant to the LGBT community. So if an employer has a policy, criterion, and practice, I'll just refer to it as a PCP, where employees have to wear a gendered dress code. So that applies to everyone equally. So men have to wear a certain dress code and females have to wear a certain dress code. But that's clearly going to place somebody who defines himself as non-binary, and so neither recognises as male or female, at a disadvantage. So that's one example. Another one that I thought about was, and this is actually the example that Stonewall use. So you have a packaging warehouse and they basically undertake training for their staff to develop their forklift truck skills and to gain a license. Now, it's the company policy, so this is the PCP. It's a policy that once somebody commences training, the details on their employee's training record cannot be altered. So it applies to everyone, but that PCP is going to place people of the trans community at a disadvantage because by the time they complete their training, the employer is not recognising that they have actually transitioned during that process. So they're just a couple of examples.
Just picking up some from the chat, one which Caitlin has put in. Maternity, paternity leave doesn't usually account for same-sex couples. So essentially saying that the PCP is that we have most likely enhanced maternity and standard paternity. Paternity leave does not necessarily have to be taken by men. Paternity leave can be taken by a same-sex partner. So I don't think that would necessarily qualify. It raises another question around whether or not that is necessarily fair to have that slant in those circumstances. There is, of course, now the option of shared parental leave, which most employers will offer the same. So there's more flexibility there to share it amongst them. It's an interesting example, though. This new message that's just coming in. Pension benefits for hetero spouses only. That would be more likely to be direct discrimination, because you're not saying we do the same pension benefits for everyone. So to link that back to indirect, if you are treating some people differently, it's direct. If you're purporting to treat everyone the same, but you create a disadvantage, that's indirect. Hopefully that makes a difference. That's a lot more subtle, and a lot more employers fall foul of it, which is why we see a lot more of these claims. Now, you can defend indirect discrimination if you have a what's called a proportionate means of achieving a legitimate aim. I could spend an hour just on that. But what that means is essentially, if you are doing something discriminatory, is there a compelling business reason that overrides the fact that you're discriminating? Is there something in play which says, okay, we are justified in having a male and female dress code that has to be conformed to because of something like that? Now, I would struggle to come up with a reason for that, if I'm honest. I don't think that would be applicable. I'm struggling to think of an environment where you need men and women to dress differently. You know, you speak to hedge funds, they probably tell you that they do, but they don't have to. So I think that is going to be a struggle. I'm trying to think. I've successfully defended a couple of proportionate means of achieving legitimate aims, but generally speaking, if you're getting to that point, you as the employer are slightly up against it. You need to be able to show good business reasons for it. Often applies in terms of part-time and flexible working. A couple of questions coming in. Marriage clauses and pensions indirectly discriminate. Come back to that. Does that include are kids at school similarly protected regarding gender identity?
Well, the Equality Act also applies to public bodies, doesn't it?
It does, yeah. So I'm thinking, yeah, so it would apply to maintained schools. I don't know if it would apply to independent schools necessarily.
No, it wouldn't. Public bodies, yeah.
Yeah. So the Equality Act would apply to schools that aren't independently owned, I would have thought.
Although, sorry, actually, although you could argue that they still have a public function, even though they're private. So, sorry, that point's probably arguable with the private schools.
You think? I haven't come across it in a private school, but the only schools I work with are generally not private schools, so I haven't had. Right. Fine. That's just chat generally, I think. Okay. On to the next one. Hopefully that's clear on indirect discrimination. Harassment, like I said, is one of those terms which is thrown around quite a lot, but it does have a legal definition. And I think harassment, if you take your mind back to the slide with the Stonewall stats, a lot of those things I described there would have fallen under the definition of harassment. So harassment is unwanted conduct, which is related to a protected characteristic or of a sexual nature, which is slightly separate, which has the purpose or effect. So that either means that it's intended to do the following things, or it isn't intended, but it has that impact, has that effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. So B being the individual, for A being the perpetrator. So to put that into a practical example, that is unwanted conduct. That is that there's a very wide range of that. That could be anything from assaulting someone to making comments about them, to talking about them behind their back, to sending inappropriate emails, to ostracizing them in a certain way from functions, things like that. All of those can amount to unwanted conduct. The unwanted element has it's a sort of to put it in later, sort of common sense test, really. If it is unwanted, if it's unwanted by you and it was reasonable for it to be unwanted by you, then it ticks that box. Violating dignity or creating an intimidating, hostile, etc. environment is just what it says there, really. And there's a sort of two-stage test. You have to have actually felt degraded or humiliated, so you have to be able to demonstrate that. But there also has to be an element of objective reasonableness. So if someone does or says something which it is entirely unreasonable for someone to take offense at, that isn't going to get over the threshold. Simply being offended by something doesn't satisfy the test. There has to be an element of objectivity to it as well. But the threshold, in my experience, Imogen, is not that high, particularly when it comes to harassment. That if people are sending, homophobic emails to one another, even if you don't see them, that's the sort of thing that would be enough. People start using homophobic stereotypes, things like that, crass language, dead naming people from the trans community. All those sorts of things are very much within the parameters of harassment. And we see a lot of these cases because you get the spectrum of these. You get the people who are openly homophobic or transphobic or biphobic who make completely inappropriate comments. And you get people who simply don't understand and who need educating, who have unconscious biases towards the community that they don't know about. They might make off-the-cuff comments that they think are acceptable, or they might not understand some of the terminology in the trans community, for example. That's the other end of the spectrum. That doesn't make it acceptable, not or condonable in any way, but it goes to the severity of the incident, which therefore goes to what Imogen is going to talk about, which is remedy further down the line.
It's also important to note at this point that actually you don't have to have the protected characteristic to be offended.
No,
so you could be an ally of the LGBT plus community and you hear or see something that you think is offensive, and that is also something that is protected by harassment. You can be harassed even though you don't have that protected characteristic.
Exactly, which I think, and that is kind of the role of allies too, I think, particularly across all protected characteristics, is to be the one who says, no, look, just because there aren't any people from the LGBT plus community in the room doesn't mean you can make, unacceptable gay jokes or jokes about women or anything like that. It's incumbent on allies to put themselves in the uncomfortable position of standing up to it. And, that's the least we can do, in my view, because that's where the change comes. The change comes from what's being said behind the scenes, what's being done behind the scenes. Like I said, people are generally not going to blurt out lots of offensive comments in front of people who actually fall within that demographic. So it's what's going on behind the scenes, that really needs to be addressed. Couple of comments from times. That's interesting. I thought the person who was targeted had to claim offense. No, not at all. There's a lot of case law about people knowing that, for example, homophobic emails have been sent between two people, and they didn't even see the emails, but they knew about their existence, and they claimed harassment. And there's plenty of cases about that being successful. It's very much designed to protect anyone who is intimidated or humiliated by this treatment of themselves or others. On to the next one, please. Victimization. Victimization is another term which is thrown around quite loosely. People say, oh, I'm being victimized for this, I'm being victimized for that. And they probably have the right idea, but it has a very specific definition. So victimization is in itself a standalone claim. I think it's a very, very good inclusion in the Equality Act, because what it does is it protects the employer or worker if they're subjected to a detriment, which is essentially just treatment that they're not happy with, negative treatment, because they've done a protected act or because the employer thinks they will do a protected act. So the key thing is, what's a protected act? Well, a protected act is bringing proceedings under the Equality Act. So if you bring a claim, if you sue your employer or something like that for discrimination, if you support someone else giving evidence or information with their claim, if you allege, going to the forefront, if you allege that the employer has breached the Equality Act, or the sort of sweep up one, doing any other thing for the purposes of or in connection with the Equality Act. What this does is, if you claim discrimination, assert discrimination, if someone else has done and you've supported them and been vocal about it, if you're then treated badly because of it, you have a standalone claim to stop this retribution. It's such a valuable inclusion because it means that people can feel confident to come forward and raise these concerns, safe in the knowledge that they actually cannot have it held against them. It's a very valuable inclusion, I think.
Yeah, thank you, Tom. Okay, so I'm going to talk about vicarious liability and what that means, but I'm going to pose this as a question again to you all. So if somebody experiences one of these discriminatory claims at work, and in particular, I'm thinking about harassment, because harassment is often going to be something that occurs, or it's a comment that has been made by another employee. So the question is then, who is legally responsible for these claims? Is it the employee? Is it the employer? Or is it both? What do you think? Yep, so somebody said the employer. We've got another taker for employer. And then a couple of people saying both, yeah. So actually the correct answer is both. So not only could you bring a claim against your colleague, but you could also name your employer. So both your colleague and your employer could be listed on a claim to the employment tribunal. So except in very small businesses, it's unlikely, isn't it, that your employer is also going to be the person who has carried out that unlawful act. So this is the principle of vicarious liability, and this is why it's very important when we come on to talk about what you can do in the workplace, that if you are in a management role, that it's also important that you recognise that if your employees are not properly trained, and if your employees are participating in discriminatory behaviour, if they harass other employees, if they send that hate mail or homophobic emails, as Tom was talking about, that actually that places your business at a risk of a claim. Now it's actually up to the tribunal as to how they decide to split the compensation. So it could be 100% attributed to the employer, even if the employee is named on the claim form. So I thought that might be interesting for you to take note of. And then finally, before we move on to some of the case law, I just wanted to talk quickly about remedy. So remedy is very specific with discrimination claims. So there isn't actually only compensation. You can also get a declaration, which is effectively where the tribunal says you have been discriminated against. And sometimes that's all people want. They want recognition that the treatment that they underwent was unfair. And there's also something called a recommendation, which the tribunal can make. So it's a recommendation that the employer improve their practices to prevent future incidents of discrimination occurring. But clearly the main remedy that is sought is compensation, and that is assessed on the basis of what we call the Vento guidelines. So this is arisen out of case law, and you can see there's a very helpful table there, which has shown you that the Vento bands, as we call them, have increased incrementally just to take into account of inflation. But essentially there's a lower band, and that takes into account minor incidences, one-off incidences. We have the middle band where most claims are kind of pitched, but as you can see, following April 2021, that band is really wide, isn't it? You know, you could be in that middle band and you could be claiming anywhere from 9,100 up to 27,000. So it's quite a wide, diverse band there. And then the upper band, that is reserved for the most serious cases. So where serious psychiatric harm has been caused as a result of discrimination, you're looking in that upper band. So most cases are pitched in the middle band. Okay, so that's the Vento guidelines. So that's kind of been a pit stop into the legal background, the Equality Act, making you aware of your rights as the LGBT community, but also the risks if you're an employer or somebody who isn't a member of the LGBT community here today. They are the types of claims that could be brought against you. I'm sorry, there's another question that's come in. If a manager is aware of an employee's disability, it is accepted as reasonable that the organisation knows about it. Yeah, absolutely, absolutely. And in fact, for some discrimination claims, it is a prerequisite, other than the indirect discrimination claims, it's a prerequisite that the employer has to know. And that doesn't necessarily mean that every employee knows. It's enough that it will be reasonable for the employer to know that, say, for somebody, one person in HR knows that you have a disability, then that would be reasonable for the employer to know about it. So yeah, thank you for that comment. Okay, so a couple of key cases that have occurred within the last 12 months. Now, the first one I want to talk about, somebody put this into the chat earlier, so this is definitely on your radar. This is the Taylor and Jaguar Land Rover Limited case. So this case came out 12 months ago. It was, the judgment was released in September 2020. And this is of fundamental importance because the findings of the Employment Tribunal in this case meant that for the first time, the definition of gender reassignment that we looked at earlier today, it also now includes gender fluidity. So there was a question earlier about the non-binary community. And whilst Tom and I were saying, well, that it's still not recognised in terms of sex discrimination, that's still very much binary, male or female, it is now included, so this is a really positive sign, it is now included in the definition of gender reassignment. So that has widened the scope of the Equality Act. So this case is also going to be interesting to you because I know that most of you have come through InterEngineering and therefore will be engineers and therefore part of this professional world. Some of you might even know people who worked at Jaguar Land Rover. So a few facts about this case is effectively Mrs. Taylor brought claims of direct discrimination, harassment and victimisation. So you can actually bring more than one of those claims that we looked at, and she brought those three. She was represented by a barrister at Old Square Chambers, Robin Moira White, who was the first transsexual barrister of her kind, and she actually joined me on a podcast. So this is a little plug here for the Law Society. She joined the Law Society to talk about that case and the importance of it. So if you're interested in that in more detail, there's also separate resources hearing from Robin herself on that. So essentially what happened is that Mrs. Taylor had previously presented as a male. And then in 2017, she began identifying as gender fluid. So she started coming into work dressed in women's clothing. And as a result of that, she was subjected to verbal abuse from her colleagues. So that fits in with what we were talking about with harassment earlier. So she was subjected to verbal abuse, but there were other difficulties which were actually perpetuated by the employer. So Tom mentioned this earlier, and I don't know why so many people get hung up on it, but there was a huge issue over the toilet facilities that she could use. And actually in that case, she was told to use the disabled toilets, which was actually found, and I will talk about this later, but it was found to be highly inappropriate because being transsexual is not having a disability. Yeah, they're completely different. And actually to say that being transsexual is in some way a disability is highly offensive. Also, the tribunals reminded the employer that disabled facilities are reserved for people with a disability. So it was totally inappropriate to insist on her using those facilities. There was also a complete lack of management understanding and support of her transition. And this is why when we come on to practical resources, we've actually tailored the practical resources out of some of the criticisms of these cases. So one of the things that management did, well, first of all, they didn't know how to implement their policies properly, but they also referred Mrs. Taylor to occupational health. So not only were they treating her as though she had a disability in respect of the toilet facilities, but they were also treating her as though being a transsexual was a mental health condition. Again, highly offensive. I mean, surely arising out of being subjected to victimization, harassment and discrimination at work, of course, a mental health condition is likely to manifest itself. But that is not to say that being a transsexual is a mental health problem. So that they completely got all of these things confused. So unfortunately, as I said, mental health problems can manifest, and it did in this case. And Mrs. Taylor became suicidal, and she was demonstrating suicidal ideation as a result of this treatment. So prior to this ruling, gender reassignment only protected people who were still on that binary spectrum. So if they were male or if they were female. So this is the first time that, and I think it's quite progressive actually, well, progressive for the law, only because the law moves so slowly. But, you know, I'm really glad that this has occurred, where somebody, the judge in this case, has recognised that gender is a spectrum. It's a much wider spectrum, and it should also protect those people who refer to themselves as non-binary or gender fluid. So I think it's a very, very positive sign that this has occurred, and hopefully, you know, we were talking about intersex earlier, hopefully there's going to be some case law on that as well. So the next case I want to talk about, although I'll come back to these both when we look at practical resources, is the Maya Forstater case. So Maya Forstater and the Centre for Global Development. So this is a recent case. A lot of you have probably seen this in the media. And this is where we get what we call like a purported clash between the LGBT community, because the LGBT community is protected under gender reassignment and sexual orientation, and we have a clash with people who have religious beliefs. And of course, if you remember, having a religious belief is also a protected characteristic. So you get like this battle of protected characteristics. Although I just actually want to say that I identify as an LGBT Christian. And so I just want to voice the fact that there are not, you know, not all people who have a religious belief are homophobic. And I certainly wouldn't want to advocate that. But unfortunately, we have seen in employment law cases that often it is the LGBT community that clashes with the Christian faith. So Maya Forstater, she was of the Christian faith, and she effectively held a religious belief where she said that gender was immutable. So you couldn't change your gender that you were assigned at birth, and she effectively didn't recognise the trans community. She was very gender critical. She held gender critical views. They were overt, and she posted those on social media and other platforms. So the organisation that she worked for became aware of these posts. They found them distasteful, and as a result, they didn't dismiss her, but they decided not to renew her contract. So in effect, legally, that is a dismissal. So she brought a claim to the Employment Tribunal alleging that she had been discriminated against because of her religious beliefs. So this case was kicked around a little bit, and at first instance, so within the Employment Tribunal, the judge actually dismissed the case, and he dismissed the case. I won't go into it now. As Tom said, we'd have a whole other hour just talking about the Granger test. But there's 5 parts to the Granger test when determining whether somebody has a religious belief, religious or philosophical belief that could be caught by that. Just as an aside, for example, veganism in the last 18 months was caught by that. So veganism was found to be a protected characteristic under religion and belief because it satisfied the Granger test. But in any event, the last part of that test was that the view had to be a view that is worthy of respect in a democratic society. And the first judge said, Maya Forstatter's views are not worthy of respect. Therefore, it wasn't protected effectively. So this went to the Employment Appeal Tribunal, and it was overturned. So the EAT sought to draw a distinction, however, between merely holding that belief and manifesting it. And what was very unusual about this case is, some of you might be in absolute dismay, you know, that the panel of judges said actually having that view, being gender critical, saying that gender is immutable, that being worthy of respect in a democratic society, you might think that's disgusting and be affronted by that. But actually what was said was actually that most, because of the society that we live in and we have the right to free speech, that actually most beliefs other than Nazism, which is definitely not worthy of respect, most other beliefs are. So that is quite shocking. But what happened was they caveated this judgment extremely heavily, and I've never actually seen that from. I wonder whether you've seen a judgment so caveated as well. But effectively, and I'm just going to express the view. So whilst they said it was protected, her view was protected, they said that the judgment does not mean that the Employment Tribunal has expressed any view on the merits of either side of the transgender debate, and nothing in it should be regarded as so doing. They also said that the judgment doesn't mean that those with gender critical beliefs can misgender trans people with immunity. They said that the judgment doesn't mean, you can see they've gone on to say what it doesn't mean in quite heavily. It doesn't mean that trans persons do not have the protections against discrimination and harassment conferred by the Equality Act. And it doesn't mean that employers and service providers will not be able to provide a safe environment for trans people. So very unusually, they were extremely careful about managing the reaction to that judgment. Now, it doesn't mean that she was successful and that Maya Forstatter will win her case. It just means it's going to go back to the Employment Tribunal and it will be heard. So it is very likely that her case will still fail. Okay, so why is this important? Why am I talking to you about these cases? There are some practical resources that I want you to take away, and some learning which we have developed in the last 12 months as a result of these judgments. Okay, sorry, there's a comment that's just come into the chat, but I'm going to choose to ignore that. So, few practical resources then. So policies are extremely important. Okay, so policies on the right of trans people in the workplaces and elsewhere, they're extremely important. They must be implemented and disseminated. But policies should not simply be a tick box exercise, because Jaguar Land Rover had policies. They had policies in place, but even the HR managers didn't know what was in them. They'd never used them. They'd never been implemented. So simply having a suite of documents that your employer has, like in a staff handbook or an employer handbook, it is not enough. There has to be training on it, and they have to be implemented. So if something occurs that actually is a breach of one of those policies, they must use that policy and manage their way through it. So if you are a manager, swift action when policies are breached is of fundamental importance. I will repeat, simply having a policy in place cannot of itself absolve an employer of liability. They must be followed and they must be implemented. Now, I've said on here Law Society Suite, so Policies Law Society Suite, and that is a little plug again, but there is a free resource. So the Law Society has actually produced a number of documents and policies which are freely available for the legal profession and other organisations. So your organisation could benefit from accessing those free policies. And one that I've recently been involved in, so I'll talk about pronoun policies on the next slide, but is a transition template. So we have, with Robin White, who was the representative in the Taylor Jaguar Land Rover case, we together have developed a transition template to use if somebody transitions at work. And so it is the perfect resource to take people through it on a step-by-step basis. It takes the employee through it. It also takes the employer and managers who might be involved in that process through it, holding your hand. So it's a perfect resource to go to. So please make sure that policies are implemented fairly, and it's quite a good example actually coming out of this case is how not to do it. So they were highly criticised by the judge, and as I said, it's a good example of how not to deal with non-binary or gender fluid people. So for example, Jaguar Land Rover insisted that Mrs. Taylor had to name names, and that if she didn't name names, they wouldn't enforce their policies. Now that is not advisable at all. There are things that an employer can do in order to demonstrate action without forcing the victim to name names in that situation. So it's also not acceptable to single out individual perpetrators either. Okay, so Robin Weiss, and I'm using her advice because she is the leading lawyer on this, she advises that the employer could issue a notice to all employees highlighting that there's been serious concern at the highest level, and the incidents have been reported to people being subjected to unacceptable harassment due to protected characteristics. So in that way, there's no need to identify individuals, but it can be circumvented because the employer is still taking action. There is a notice to everyone that this behaviour must stop, and it is taken very seriously. So the safe and inclusive environment, I think this comes back to what we were talking about with harassment, because there is a line, isn't there? We were saying that some people are simply uneducated, but there's also willful harassment. But there's this line in between where we have the word, and I hate this word, the word banter, because I hate that word because it can excuse a whole host, or attempt to excuse a whole host of offensive behaviour. So what I'm saying here, safe and inclusive environment, please be wary of banter. So the engineering industry, interestingly, has been regarded historically as being more traditional. And for some reason, the Employment Tribunal has actually distinguished between language used in different professions and has held different standards to different types of job. So say, for example, in the construction industry, it was deemed appropriate to use swear words and to swear at one another in the workplace, and that was deemed not to be offensive. But what this case tells us is that even in industries that have previously been regarded as more traditional, there is a move away from accepting banter as an excuse. So there's less and less tolerance for comments concerning gender identity. And it's really important that your colleagues, I'm sure you don't do this yourself, but you don't go beyond what is professional, particularly when you're commenting on other people's appearance or lifestyle. So just moving on to toilet facilities then. It's not acceptable, as I said earlier, arising out of this case, to make a trans member of staff use a disabled toilet. Maybe that's acceptable as a temporary solution, but it must not be a long-term solution. As I said earlier, their presentation is not a disability, okay? And then finally, occupational health. So again, this case tells us that referring somebody to occupational health support is not appropriate. Being trans does not mean that you have a mental health condition. You may have a mental health condition separately. The Forstater judgment, slightly different. So we've had a lot more progressive and resources that have come out of the Jaguar Land Rover case, but Forstater really, I think, is talking about belief. So I wanted you to take away with this about being able to feel comfortable and challenge offensive views in the workplace. And I think it is absolutely appropriate to do this informally in the first instance, because it is about educating people. It's not always about punishing people for getting things wrong. And I think that's really important when it comes to, say, misgendering somebody. If it's not deliberate, if it's accidental, there is a lack of education there. So if you can deal with things informally in the first instance, then I think, you know, that is great. But if there is something that is continuing and is clearly deliberate, so if an employee assists with that, then that should be raised formally. And if you are aware of other people using transphobic or gender critical or homophobic comments in the workplace or in social media, if it can't be dealt with informally, then that should be raised. Because what the tribunal said, even though people may hold those beliefs, what the tribunal said is it's about the manifestation of it. So of course we can't govern, we're not Big Brother, we're not the thought police, we can't govern what people think or believe, but we certainly can ensure that the way that they present that doesn't manifest in something that is discriminatory, dangerous or offensive. Okay, so finally then, this is the last slide. Thank you for sticking with us. So what can you do? Okay, so what can you do following today's talk? So the first thing is to consider what policies your employer has in place. Okay, so can you review anti-bullying policies? Do they even include bullying LGBT members of the community? Does it even include bullying trans people? So is it fit for purpose? So the first thing I want you to do is actually check what policies your employer has in place. Now, as I've pointed out earlier, there is those free resources from the Law Society that you can download and access. And of course, if you want more tailored policies, then Thrive Law can help you do that. Introduce a pronouns policy, so that you may see that some people have, and Tom and I both have this after our names on LinkedIn and also after our email signatures. We specify how we define our pronouns. So for me, it's she, her. For Tom, it is he, him. For the non-binary community, you might see something like they, them. So introducing a pronouns policy is important because it's part of creating that safe environment. If we start displaying our own pronouns, what we're doing is we're inviting other people to share theirs. So we're saying it is a safe environment for you to define yourself, present yourself in however you would like to and however you feel comfortable doing. Okay, so it's just inviting and starting that conversation and saying we are a safe place. Diversity and inclusion training of staff at all levels is also really important. As I said, having policies is great, but if you don't know how to use them or implement them, then they're not worth the paper they're written on. They're a brilliant starting point, but you must train people on how to use them. And also it's quite interesting to know, just from a stats perspective, whether or not your employer is actually diverse and inclusive. So collecting data and monitoring that data is also quite an important thing to do. I would also suggest, if this is something you've been interested in, I would love to encourage you to set up an equality and diversity committee within your workplace. So within my workplace, I'm the LGBT champion. And we all try, because we're quite a small firm, we all try and champion one of the protected characteristics. So I'm the LGBT champion. We're not large enough to have a committee, but certainly this is something in the larger organisations you should be doing, because you're not only creating something that is visible, you know, so it's part of that creating a safe environment. You're saying that we are visible, we are here. You are setting yourself up to be a positive role model, and also you're creating a place and a number of employees where if there is a problem with diversity, if there is a problem with harassment, if there is a problem with discrimination, there is a place that that employee can bring that issue to, particularly when we're thinking about not necessarily overt discrimination, but those issues of indirect discrimination. You can work together to change policies and practices for the better of the community. So that's a really, really great idea if your firms and organisations don't have that. So yeah, I think I mentioned this actually above. So undertaking research to determine whether the employer is attracting a diverse range of staff, because if it isn't, then what does that say? What are the obstacles? If it isn't representative of the community that we live in, then there is some kind of obstacle preventing people from the LGBT community from even applying for those roles in the first place. So understanding what those barriers are, and then potentially having an equality and diversity committee to help overcome those barriers is brilliant. Okay, so consider training on subconscious or unconscious bias. We've seen this quite a lot in terms of racial discrimination. I haven't actually yet seen anyone who's delivering this in terms of the LGBT plus community, but it's also important to be aware that discrimination can occur on a subtle level. Gender neutral toilets. Again, I don't know why people get so hung up on this issue. It's not a problem for us at the workplace. Our toilet facilities are used by everybody. It's not an issue, but for some reason...
Can I jump in on that, Imogen? Sorry, can I just jump in?
Yeah, no, please do.
A couple of years ago, I did quite a detailed paper on this for quite a big police force because they wanted some advice on it. And this also links to a comment that I think Adam just put in a few minutes ago, said if we're all comfortable with disabled toilets being unisex, why not all toilets, which is just what you were saying. And the Home Office did this in one of their buildings. They spent about £50,000 on making all of their toilets gender neutral. So all sort of separate cubicles, presumably. And there was an absolute uproar because the women said, you disgusting men can't keep these things clean. You just pee everywhere and don't put the seat down, and we don't have our own loos anymore. So interestingly, it turned out to be a complete disaster. So what I've always recommended is have male toilets and female toilets, but also have gender neutral ones. So have 3 blocks of toilets if you have the space to do so, so that there is a gender neutral group of toilets, but the shrine of ladies' loos is still in existence and isn't ruined by people coming in and weeing all over the seat. It got really negative publicity from a really intended sort of positive move. Yeah, you would expect adults to behave better, but I think until some men learn how to be more hygienic, that seems to be the direction of travel for a lot of employers, is to cover all those bases. Sorry to interrupt. I just wanted to...
No. I'm glad you did, actually, because I realised it was my voice dominating for a while, so it was really nice to have that interjection. In fact, I'm really proud of the University of Law, who I also work for, who have done just that, Tom. So they have 3 blocks of toilets. However, with the trans community, I think what one of the issues is, and I find this very upsetting, is that some groups of people who refer to themselves as feminists would say that trans women are not women and therefore are prohibited from using the ladies' facilities. Now, the transition template that I have drafted in accordance with the law and with assistance from other members of the Law Society, and in particular Robin White, our view is that you encourage your employee who is transitioning to use the facilities that they feel most comfortable using. Okay, so that's the view that that I've taken on that.
There's an interesting question here from Lynn. Have you seen this question from Lynn on the chat?
Yeah, go ahead, Tom.
Yes, we have an option to add our pronouns to our email signatures. Some people have pushed back and said pretty vocally they don't think this is a subject for the workplace as it's too political. What's your views on this? Well, pretty firm view that they're wrong, Lynn. It's not a political issue. That it's not like you're putting, Conservative or Labour in your email signature, or or Catholic or Protestant or anything like that. This is it's an innate part of who you are as a person. And anyone who says it's too political, I imagine, is almost certainly heterosexual and therefore doesn't see the need to have something to help to identify themselves, to promote themselves. So I think that's a very narrow-minded approach. And I would hope that the employer would be far more open-minded than that. I think that would be a very disappointing stance to take. Would you agree, Imogen?
Yeah, interesting that it's an optional policy as well. So the fact that it's optional, I think that some employers have taken the view that actually they don't want to force non-binary members of the community to come out. But I totally agree on the political point. This isn't political. Tom, you said it perfectly. You're not saying which way where you're voting, but this is really important to create safe and inclusive environments. And if we're not doing that, and if we're not doing this step, then actually what we're saying, and unfortunately those people who are challenging it in that way, they are saying that discrimination on either a conscious or a subconscious level is acceptable. That's the way that I read that.
Exactly that. Because, if someone wants to put, for example, they or them, then someone is referring to that as being political. Well, why? If that's how someone identifies, that's part of who they are, why is it appropriate to stifle that? Of course it's not. That's very disappointing.
Something that we're actually also discussing, and this is particularly relevant for the legal profession, but whenever we start correspondence with somebody that we don't know, it has been the long-standing tradition to write "Dear Sir / Madam," and actually we have been having a conversation internally about how we're going to change our drafting to make sure that it is gender neutral. So say for example, if we're writing to ACAS, actually putting "Dear ACAS Conciliator" is gender neutral until you know somebody's name, and then you can start using their name.
Yeah.
But there's just, you know, things that we have done because we've always done it that way. It's traditional to do it that way. We're now starting to recognise could in fact be discriminatory. So we're challenging that ourselves, and that's something that you might want to do in terms of drafting. And then finally, the other thing, I don't know whether many of you have uniforms, but you know, we were talking earlier about that indirect discrimination example. If you're making people wear gendered uniforms, then why? Why are we doing that? Why don't we have a gender neutral uniforms like nurses, for example? All nurses, male or female, they wear the same clothing. It's non-discriminatory in that way. So they're just a few things that you can take away, that you can start doing, you can start actioning and taking control of these issues in the workplace. If you need assistance doing that, of course, you've met Tom and I now. You can come to Thrive Law, you can get assistance from the Law Society, but there's also some really great organisations who are probably doing things, and I must say, you know, better than we are, because they focus on it all the time. So, you know, we're great, but I would say these guys are greater. So the Global Butterflies group, absolutely fantastic for delivering training, corporate trans and non-binary inclusion. So I know the lady that operates Global Butterflies. She's a trans female. She is absolutely fantastic, and she can deliver specific training relating to the trans community. There's also mermaids. Oh yeah, Rachel is absolutely amazing. I'm glad people have heard of her. We've also got mermaids, who again are a charity. I know Louis Asquith, who's the legal director there, who identifies as non-binary. And they in fact did a talk for Thrive on the non-binary community. So great stuff. We've also got SAIL, Stonewall, and the Gender Identity Research. So they're good resources to go to. But of course, I hope that people who have attended today haven't had the experience of discrimination. But of course, if you feel like there's something that isn't right at work, if you feel like you've had an issue at work, then this is where Tom and I can really help. So we can help with those policies. But if you just feel that something isn't right, or you feel like you've been the victim of discrimination, as we've been talking through today, then please do speak about it and come to Tom and I for support. Tom, is there anything you want to add?
I'm going to put a small plug in a minute, but just to pick up on Caitlin's question, which she's asked, which is, have you had any cases where LGBT people want to bring a case of discrimination or harassment but don't want to out themselves? Is that possible, since you said you don't have to have the characteristics to claim harassment? Caitlin, I think you've probably answered your own question there. Yeah, you could bring a harassment claim without having to talk about your own sexual orientation. You could be offended by comments, emails, etc., without having to out yourselves. You could just say, I find that offensive and it relates to the protected characteristic of sexual orientation. You don't have to have that yourself. For a harassment case, harder for discrimination, particularly direct discrimination, I imagine, because if the employer does not know what your sexual orientation is, it's very hard for them to be holding it against you. They may have made a decision which you feel perhaps there's an inference that it's because of your sexual orientation, but it can't be if they have no idea what that is. You can't use something against someone or take it into account as a factor if you don't know it exists. So far more likely for harassment than for discrimination. Good question, though. Interesting.
I've just been asked whether I can share the link to the Law Society website, and unfortunately I can't because I'm the one that is hosting and sharing the screen. So to do that, I would have to leave this screen, and I can't do that. But if please contact us. And I think we've also got your emails from you having registered for this event. So that is definitely something that I think I can send round after the event. In any event, if you wanted to just search that, just searching Law Society transition template, I'm sure Google will bring that up. And at the bottom of that page, there's also links to a suite of documents that I have helped draft with the Law Society. So there's an HR guide, a manager's guide, there's a free pronouns policy, and the transition template that I've been talking about there.
The only thing that I wanted to say, which was our plug, was that if you found it useful today, this is such a topic that we want to get more dialogue going. We want to get more people talking about this. If you feel comfortable, please feel free to put something on LinkedIn to say that you enjoyed it, about the event, how useful it was. Because the more that we can get in front of people to have these discussions, then the better that is. I appreciate some people may choose not to talk about it so publicly, but if you've enjoyed it and feel like you want to talk about that, LinkedIn is a great forum for us to be able to sort of comment and share and to raise this discussion across our sector and yours. Other than that, thank you so much for attending.
Yes, thank you everybody, and thank you for engaging in the chat.
Yeah,
It's been great to see your comments coming through. So keep in touch.
Yes, thank you everyone, and a big thank you to Imogen and Tom as well for doing this presentation for us. Have a good evening, everyone. Thank you very much.
Thanks, everyone. Good night.